I mean, the only thing I can think of is, in order for it, in his mind, to be relevant, there has to be some testimony from the defendant about his state of mind. Because what he did tell the defense was that this guy can talk about suicidal risks, but can't talk about the state of mind of the defendant, right? So he can talk about generalities, but not about this defendant. So that's the only thing I can think. Maybe there's a relevancy issue.
Yeah, I could see how he would think that. But if the suicide expert were to testify and then the defendant didn't testify, I could see in closing arguments his counsel putting the pieces together for the jury and say he was, you know, he was going to kill himself, because one of the things you could do as a defense attorney is say, my client didn't do it, somebody else did it, or maybe somebody else did it. So, I mean, it becomes a thing where, why, if you don't think it's going to be helpful to him, Your Honor, why care? Why not let us try it? This is what we want to do. And by the way, he may testify. Yeah. We just don't want to agree to it right now, because if you're the defense, you don't know if your client's going to testify until the last moment for a reason.
Sure.
So the judge is forcing them to make that decision early on in the case. I think that's the basis of his mistake.